South African Self-Represented Litigants Association has been established as a new national civil society organization, which founders say is intended to be the voice of the voiceless in South African courts. Statistics show that 62.7% of people who went to court represented themselves, while only 20.8% had legal aid. The group's Henry Sambane joins us now for more. Mr. Sambane, good to have you on the program this evening. So the Stats SA survey shows that about 62.7% of people who go to court actually represent themselves. What does this number tell us about the state of access to justice in South Africa today?
The numbers tell us a simple but a painful story, Nhlanhla. For most people in South Africa, self-representation is not a choice, it is a necessity. If we break it down, as you already alluded, 12.9% with private lawyers are the small group who can afford attorneys and advocate for months or years, because we normally budget for once off. Now, 20.8 with legal aid are those who fit the income and asset test, and where legal aid has a capacity to take the case. That leaves 62.7, almost 2/3, who end up in court with no lawyers at all. But why? Most people simply cannot afford private legal fees, especially after retrenchment or business closure. Many fall into the missing middle. They earn slightly above the legal aid threshold or own a modest house or pension. So on paper, they look too rich, but in reality, they are cash poor and cannot afford litigation.
Yeah.
Legal aid, law clinics, pro bono structures have limited capacity. They cannot cover every eviction, death case, labor dispute, or pension fund fight. Some people start with a lawyer, but when the money runs out, the attorney withdraws and the pension is left alone in the middle of the case. Now, South African Self-Representation Litigation Association was founded because in our courts today, the typical litigant, it is the self-represented person, not the one with silk at their side. Until now, there has been no dedicated national body to support them or speak for them in the legal system. In short, South African Self-Representative Litigants Association, we call it SASLA, was created to close that gap.
Right. Mr. Sambane, you yourself, I understand, exhausted more than 400,000 Rand on legal fees before, representing yourself in multiple High Court matters. Let's speak about this. How did your personal experience then shape the formation of your association?
Nhlanhla, it was really very difficult. I started with a lawyer, and in the middle, I exhausted my 400,000, which was budgeted. So I had two options: walk away and lose everything, or teach myself how to litigate. I chose to learn, drafted summons, affidavit myself, managed discovery, tracked deadlines, and started arguing in the High Court as a layperson. Standing there in court next to the counsel from big firms, I realized if it is so hard for me with my education and executive experience, how much harder it is for a mine worker in Kriel, a nurse, a teacher, a taxi owner, a spaza shop owner. That's why I said we need an organized national response. So SASA is about taking that painful personal journey and turning it into a structured support, practical tools and collective voice for self-represented people and their communities.
So, Mr. Sambane, the Stats SA report also shows that 92.9% satisfaction among self-represented litigants, which is surprisingly high, I must say. How do you interpret this? Is it true empowerment, or are people satisfied simply because they cannot afford other options here?
No, since it is not an option, they have to go to the courts. The last time I went to the court, it was in October the 13th. And in Tlantla, you cannot believe it. It was a undefended cases. Yeah. We call them unopposed case. One judge was sitting with more than 67 cases, and it's 3 courts. You can calculate it's more than 200. And those people are not defended by any person. Now, take alone, those are not defended themselves. But those are defending themselves, they go in unprepared, and in the first place, there's a disadvantage, because if you defend yourself, you cannot claim legal cost. You can claim only reimburse. Now, people, those are represented, they've got an advantage because they can claim cost against you. And if you are not prepared, you are going there in the fire, whereby you'll come back with 13 million low cost.
Right, Mr. Sambane, as we wrap, South Africa has no official national body which represents self-represented litigants, unlike, for instance, Canada and the US, I believe. Let's speak about this. What lessons have you drawn from those international networks, if you will, that could indeed work here?
We have started a relationship with Canada, which we are exchanging notes because we are a very new organization. The lessons which we have learned from them is that their objectives are set around to our objective. One, it is to support, educate, empower, guide, and prepare self-represented litigants before, during, and after civil and labor proceedings in the High Court, Magistrate Court, Labor Court, CCMA, and other forums. Second one, it is to promote access to justice and the constitutional right of access to courts for people who cannot afford lawyers. Thirdly, develop plain language of information, because the language which is used by the courts, it is not so much friendly to our people. And training and practical tools so people can understand rules, draft and organize pleadings and affidavit, manage timelines, correspondence, and prepare for hearing and settlement discussion. Most of our people, their cases get eliminated because of the time frame. They are not very au fait with time, because time is so crucial. For argument's sake, if you have to respond for a sermon, within 10 days, you must file an intention to defend. And within 20 days, you must file an answering affidavit. A layman doesn't understand these technicalities. So our organization, it is there to educate our people, to support our people.
Right.
And it is not only legal, Nhlanhla, it also brings psychological issues and emotional issues in families, because once you become a self-litigant, you must know that you lose friends because you talk a different language. You also have a possibility to lose some of the relationship with your families. Now, people start to have a constant anxiety because why? Every letter, email, or SMS from the court or an opposing attorney feels like a new crisis. They also suffer shame and embarrassment because people feel they have failed because they can't afford a lawyer, especially heads of household. There's two cases in my mind. There's a case at the High Court in Free State High Court, and there's another one in Durban. And these are very senior civil servants, those who cannot afford um, um, legal representation. And I think they've got, currently they should be suffering from a chronic stress.
Gotcha. Thank you so much, Mr. Sambane. Henry Sambane from the South African Self-Represented Litigants Association. A big thank you for him to join us this evening. Of course, as the majority of South Africans continue to face courts without legal representation, this association's work may become very critical in reshaping access to justice, dignity and fairness in our legal system as well.